Ms. McMinn.
May it please the court, counsel. On March 2nd, 1984, Glenda Moore was found guilty of first-degree murder. I think there's two bases for granting him a new trial. He's entitled to a new trial because, first of all, he didn't get a fair trial the first time, and he's entitled to a new trial because there's a reasonable probability that but for the introduction of what we now know to be junk science, he would have been acquitted. The record here is full of things that denied Moore a fair trial. First, of course, and most important, is the CBLA testimony. CBLA has an interesting history. Comparative bullet lead analysis was highly regarded in 1984. At Moore's trial, Mr. Roger Asbury, an expert witness from the FBI, told the jury that he had conducted tests on 2 bullets found at the scene and 1 bullet taken from Moore, and that it was his opinion that all 3 bullets could have originated from the same box of cartridges. By 1995, the FBI announced it would no longer use this CBLA testimony. I can imagine the impact this testimony must have had on Moore's jury. Moore was denied a fair trial because this false evidence carried the prestige of the Federal Bureau of Investigation. As the Court of Appeal on Moore's direct appeal also noted, this evidence so undermined his credibility with the jury that the introduction of other improperly admitted evidence was harmless error. The jury was flatly told that science proved that the murder bullet came from the same box as the ammunition found in Moore's possession.
Well, what do you make of the defense expert who, from the University of Missouri, who testified that basically that you couldn't draw the conclusions that the FBI was testifying about? I mean, basically, bottom line is you had a rebuttal expert who today looks pretty good.
I think in 1984 he probably didn't look as good because that was just, FBI used this evidence for well over 20 years, and it was highly regarded as the standard and scientifically correct. And in 1995, in fact about a year before that, there was an internal memo in the FBI that said, wait a minute, this doesn't look like it really is able to purport what they claim it does. And then sometime later, the FBI has actually joined with the National Association of Criminal Defense Lawyers to look at over 2,500 cases where this was used. Adding to the denial of the fair trial was the testimony of this Dr. Campbell that Moore was exhibiting exaggerated symptoms right after he was taken to the hospital at the time he was being questioned. And on the first appeal, the court found that this should have been inadmissible, that it shouldn't have come in, but it didn't make any difference because of the overwhelming evidence from the CBLA testimony. At the time of the direct appeal, CBLA had not yet been discredited. Now, if you go back and look at the other evidence and testimony in this case, you have things like George Feeser, the owner of a storage facility in Paducah, Kentucky, testified that his facility had been burned shortly after Moore ordered some of his property moved to Iowa. This was highly prejudicial and I contend was without any probative value. It merely invited the jury to speculate that Moore might have somehow been involved with the fire. Also, a fire was set or attempted to be set in the victim's car, and the state tirelessly tried to find evidence that Moore had purchased this kind of paint thinner that was found in the victim's car. No link was ever found between Moore and the can of paint thinner, and no fingerprints were found on the can of paint thinner.
Agree that the legal standard, though, under our law, that assuming the CBLA evidence never should have come in, and assuming that the discovery now that it's, as you put it, junk science, is newly discovered evidence, we still have to find that that a new trial, it would probably change the result if a new trial is granted. Isn't that what the case law says?
I believe it does, and I think if a new trial, I think from the evidence that was left after you take out the CBLA, that there is a probability that he would have been acquitted.
You still have the defendant with the victim 30 minutes before the victim is murdered
Yes.
by somebody. Then the defendant found driving away from the scene 45 minutes later, about 45 minutes away at a speed that would have just about gotten him there if he was driving directly away from the scene. And you have an eyewitness, admittedly a young boy, but still an eyewitness. And you've got also the kind of this suspicious behavior of the defendant, where doesn't say that he had seen the victim earlier in the day, claims he's got a medical problem so he can't answer police questions or have an interview, but nobody can find a medical problem with him, all of that. Isn't that enough to give you confidence in the verdict even without the CBLA?
I don't think it is, because the kind of things the state relied on, this Jeffrey Elmore, who was the teenager, who was the state's only witness that really connected him to the scene at all. He wasn't able to identify Moore in any pictures or any lineup prior to the trial. He only identified him from the witness stand sitting at counsel table. I think there were a lot of problems with Elmore's testimony. Also the fact that he had received an reward for coming forward, that wasn't revealed to defense counsel. He wasn't able to possibly impeach him based on that. And naturally, Moore's fingerprints were found on the car. He and the victim were engaged. He lived at her house. He had met up with her at the grocery store shortly before the incident, helped load her groceries into the car. He said that he was going over to Illinois to look at a sign that advertised some property. There was, and he did get a ticket. He called the daughters collect, said he was having car trouble. I think one of the big problems is, though, with Moore, is that he was so impeached by the admission of the CBLA testimony that he really didn't have any credibility with the jury. Then later on, if you take that testimony, I think we'd have a considerably different situation. And a lot of the evidence that was offered by the state was more in the line of he's a bad man, character assassination, innuendo, that sort of evidence was used against him.
They did have evidence of motive in that she wanted to end the relationship, and he also had a $50,000 life insurance policy.
They did have a witness that testified that was a girlfriend of Juanita Townsend that said she'd had lunch with her 3 days before, and they'd gone on, Juanita and Glendale had gone on this trip to Missouri together, and that she thought she was probably going to end the relationship. Now, she hadn't revealed this to her two daughters, but they did have testimony that said that. And they'd taken out life insurance policies. I think if he had died, she would have gotten $100,000. She died, he would have gotten $50,000. The other $50,000 would have gone to her daughters.
I know the same box evidence has been determined to be the junk science as you've described it, but there was a cartridge found in his pocket, and the cartridge was similar to the one found in Townsend's car. And so how do you reconcile that?
Well, it was the same type, but with the FBI testimony that it came from the same box, I think that makes a big difference. And also, looking into this guy's background, I think at one time he was a licensed firearms dealer. He always had plenty of
But he
guns.
said he had no idea how how the cartridge got into his pocket.
That's right. He maintained he did not know how it got there.
So if you take out the junk science, there's still evidence of a cartridge that was similar to the one recovered at in the vehicle, which he had no explanation for.
That's true. He had no explanation for it. And like I said, he was, by the CBLA testimony, he was pretty well impeached. I think the court had found that he was not credible. But like
Well,
I
he
s-
also, and correct me if I'm wrong, we're throwing snippets of facts, but we're trying to understand it. He denied in a police interview that he had any financial interest, and he was specifically asked about insurance, I think, and he said no. But of course, in fact, that wasn't true. So, you know, I mean, first of all, do I have that right? I think I do.
I think you do.
I think I do.
Yes.
Okay. You know, this is an interesting case. It's obviously largely circumstantial evidence, but you put one circumstance, he has a bullet, a cartridge actually, in his pocket. He doesn't know how it got there. In and of itself, interesting. But then he's got a financial interest which he denies. Interesting. He gets picked up speeding, kind of going in the wrong direction. Interesting. You know, you see where I'm going, I think. I
Yes.
mean, ultimately, you stitch together these circumstances. And I want to, you know, kind of invite you to lean back against the theory that, you know, there were errors made, but you haven't crossed the relatively high bar for, you know, a new trial based on newly discovered evidence in a PCR proceeding.
And I think you're correct in the record that there was, what you said is correct. But you look at the other evidence the state brought in that was such like, there was a fire started, some years ago you told a deputy that you had a 357. At the time you were arrested out in Montana, there was a bulletproof vest in your car. There was a lot of things that came in that I believe really wasn't admissible and was character assassination. At the same time, there was some evidence. Jeffrey Elmore, of course, was, I think, the only witness that they had that testified he was actually at the scene. And Elmore's, I don't think Elmore was credible, but if you
He was
take.
but at trial, he was pretty vigorously cross-examined, I think. I mean, you know, you read the testimony, he's a young man. He's involved in juvenile issues. You know, I mean, I wonder how much weight the jury really gave to that. I'm asking the question and inviting pushback, of course.
I think the biggest weight that they gave to anything had to be the CBLA testimony. I know if I'd been on that jury and heard everything that they brought in, and then the topping on it is, and guess what? He had a bullet from probably the same box as the bullets that killed the victim. I mean, that had to definitely tip it in the state's favor. And I still contend that without that evidence, there'd have been a good probability of a different result.
Thank you, counsel. Ms. Soich.
May it please the court. Good afternoon, Your Honors, counsel. Your Honors, the compositional bullet lead analysis evidence in this case was not important in the scheme of things when one considers the overwhelming evidence against the defendant. Now, I believe it was Judge Slagle who wrote the initial Court of Appeals opinion who found the privileged testimony harmless. And I remember arguing in front of Judge Slagle many times where he actually said to the lawyers, I don't believe in the concept of harmless error. He was very hard to convince that any error was harmless. But even he found, writing for that court, that the error was harmless. And if the court reads
But on the bullet testimony, if you look at closing argument, I mean, historically, this is kind of an interesting exercise. You look at closing argument, you look at what the the lawyers are emphasizing to the jury, and the prosecutor really pounded the bullet testimony and lauded the FBI as kind of this, I mean, I'm paraphrasing, but you know the passage I'm referring to. I mean, kind of lauds the FBI as being, kind of the G-men, and criticizes our friend from Missouri as kind of being one of those academic types or whatever. But he's making a significant statement to the jury about the testimony. And then I kind of linked that with the Court of Appeals in the first PCR, which says, well, it was harmless error. See the CBL testimony.
Your Honor,
Yeah.
I think they say, see the fact that the bullet matched, not the compositional bullet lead
Well,
analysis
yeah, but
testimony.
look at the testimony. I mean, that's what you mean by, quote, matched.
But I would argue, I'm sorry, Your Honor, I should let you, I would argue that a match is the fact that, as you've noted, Glendale Moore is going to the police station that night, just several hours after the murder. He starts to be interrogated by the officers. He starts to claim that he has chest pains. He goes to the hospital. They check out his pocket, and they find the unfired cartridge of a .38 Federal brand of ammunition in his pocket. And as the court has already noted, he has no explanation for that. He says, I have no idea how that. So I would urge you to
but
find,
they
Your
went
Honors, that that's a match. That.
But they went beyond that. I mean, I think it is clear that the cartridge found in his pocket could have been of the same variety that was found in the car, 2 slugs. But the testimony of the FBI witness went beyond that. It wasn't merely the consistency, although he did say that. But then he goes on to say it came from the same box, and that's why you got the letter in 2009 saying, oh man, so.
Your Honor, he said it certainly could have come from the same box. He didn't say, and I know we parse words all the time when we're looking at expert testimony here, and what he said was, it certainly could have. I would direct you to page 130 of the appendix, 131 and 132, and that's not even when he says that part, but that's when he's sort of starting out his analysis. And he says 2 or 3, I believe it's 3 times, I'm not saying that each box has a unique composition of bullets. And he's saying even within one box of ammunition, you may have 1, 2, or 3 different types of elemental compositions of bullets. He says, but I am saying that the closer we get to going to a certain manufacturer on a certain day and buying a certain box and then another box, that they might have a closer association. So, Your Honor, I really do think he does hedge when he testifies. It certainly could have come from the same box. It's what I expect. I've seen the testimony in other.
And
But, Your Honor, he's also crossed and testifies, and this is, I think, on page 850 of the record, and I apologize to the court. In designating, in this case, I did not designate.
we'll look at the whole thing, don't worry.
Yes, and so on page 850, which is not in the appendix, but which is of the trial transcript, page 850, he admits that there are between 37,000 and 42,000 bullets which could have the same compositional elements, which could essentially match. So this is not this overwhelming smoking gun evidence, Your Honor. This is evidence where he tries to at least put it in perspective to the jury that this isn't like a fingerprint, this isn't like DNA. There are a lot of bullets that might match.
Well, it may not be like DNA, but if you consider all the bullets or try to conceive everything that might be out there, even if you're talking about the numbers that you've just mentioned, that's pretty damning evidence, isn't it?
Your Honor, it does not seem damning to me. If you say 37,000 to 42,000 bullets could have had this same exact composition, that really.
Is there accompanying testimony about how many bullets would be out there? Is there a ratio
I don't believe
here?
there was in this case. I know in some of the cases that discuss this, they talk about how there are a tremendous number of bullets out there.
3 million guns out there. Think how many bullets we must have out there.
No, there are a lot of bullets out there, Your Honor.
So if someone has, if there's testimony that you have a box of bullets, and I don't know how many boxes we're talking about to get 30,000 bullets that would match, but it may be fairly damning to have that evidence put into your trial, isn't it?
Your Honor, I don't think it's fairly damning when we consider all of the other evidence that was against this particular defendant. Again, even looking at just the fact that he has the 38 bullet in his pocket that very night, and the fact that he was known to carry a .357 Magnum, which was capable of shooting the 38 bullet. That was his weapon of choice that he carried every day. Not to mention, Your Honor, and several members of the court have indicated different pieces of evidence that tend to establish this defendant's guilt. I would perhaps like to go through a few more of them if I could, but I would say, again, Jeffrey Elmore, if we look at Jeffrey Elmore, I think when the jury looks and compares this compositional bullet lead analysis with Jeff Elmore's testimony, I think they're going to actually be much more focused on Jeff Elmore's testimony. The compositional bullet lead analysis testimony, Your Honors, as you know, is difficult to read. It's difficult to understand. Again, he does not couch it in absolutes. That we do have another expert, Dr. Steve Morris, an academic, but still an expert. He testifies. We quit doing this in 1973. This is not good science. This is not something that they should do. We also have, Your Honors, a federal ammunition brand employee called to the stand, and that is some mind-numbingly technical evidence, but he goes on for about 30 pages about the procedure, and the procedures of how to make the bullets are important because that's what
Let me interrupt. I mean,
Yes, Your Honor.
it is a really, in fact, intensive analysis of this, and I'll tell you where my concern is we need to look at this under the totality of the circumstances, and what drives me or concerns me a little bit here is we have certainly the exclusion of that opinion and the testimony of the CBLA. You know, then in one of the PCRs, then we have the exclusion of the testimony of the doctors and the nurse. Then we have the testimony that wasn't forthcoming as part of the eyewitness, Elmore, who's there. And so you see, to me, it's starting to develop a little bit of an accumulation of events that gives me a little pause to say, well, was it all fair when you start chipping away one thing after another in these various PCRs and in other cases that we've had on direct appeals and things too? You see where, when we get down to the basic issue of whether this was a fair trial, is he going to have a fairer trial if he has another trial without all these things in it now?
Your Honor, he would have a different trial. I don't think he would have really a fairer trial. And I understand your concern about subtracting out the things that have already found to be objectionable. But if we had 4 pieces of evidence essentially against the defendant and we subtract 3, then we don't have much left. If we have many, and again, they're mostly circumstantial, but not all, pieces of evidence against this defendant, then even if we take away 3, we still have evidence. And Your Honor, when we talk about Jeff Elmore, if I could return to him for a minute, even if we look at the idea that, well, there was a reward and it wasn't initially disclosed, we have to also consider the fact that he came forward 10 days after the murder. He told his behavioral counselor, he had seen or read about the article in the paper about someone being murdered in the Schwinn-Becker parking lot. He said, I was there that day. He described everything. And Your Honor, I think what's important in evaluating his testimony is even if we say, well, it was suggestive, unduly suggestive because he pointed him out at court and he didn't pick him out first, we still have all kinds of things that I think make his testimony extremely compelling. Things he couldn't have known. We have the fact that he heard 2 booms and there were the 2 gunshots. We have the fact that he identified Juanita Townsend's car as the white car, the white Chevy Citation. He identified the defendant's car as the other car that he saw the defendant go over to. He identified the paint thinner or mineral spirits white container that he saw the defendant sort of spreading around. He identified the fact that the defendant had a beard. He identified, I think probably much more importantly than a beard, that the defendant walked with a limp. And Your Honors, I think the fact that this defendant had an artificial leg and this young boy who's cowering in this parking lot says, I saw somebody walk with an artificial limp is very compelling evidence. And finally, Your Honors, he identified the fact that the defendant had this flashlight, and he had the flashlight on a kind of a nightstick-like ring that he wore on his hip, and he talked about that. The police later found in searching the defendant's car a flashlight with that nightstick-like ring. So again, I think Jeffrey Elmore's testimony is quite compelling when we look at all the things that he could not have possibly known, even if we completely take out the face-to-face identification at trial. Just all of the other facts, there's no way he could have known. So when we combine Jeffrey Elmore's testimony, the fact that, again, he does have a financial motive, he lies twice to the officers and says, no, I have no financial motive. We know that he's in financial trouble before the murder occurs. He is the one who pays for both insurance policies. They're taken out 3 months ahead of time. Again, he gets $50,000, but lies about that. So we have all of that motive. We know that she's going to break up, that Juanita Townsend is going to break up with him and anticipates that it will not be easy. We know that he is seen with his ex-wife a couple of days before the murder, a couple of days after the murder. And I know that the applicant will argue, well, that doesn't make him a murderer. None of these facts perhaps by themselves make him a murderer, but when we add up fact after fact after fact that this jury heard, and Your Honors, this was a 2-week trial. The compositional bullet lead analysis was not a very big part of this trial. And again—
Can I ask one question?
Certainly.
Judge Warling, I mean, he's an experienced good judge, but he does say something that bothers me at the end of his PCR ruling. He says, in denying relief, a reasonable jury could conclude that Moore was guilty beyond a reasonable doubt based on the totality of the evidence. That strikes me as not really the right standard.
Do you think, Your Honor, that that's for the due process standard rather than the newly discovered evidence standard?
The issue really isn't, is there sufficient evidence to support the jury verdict without the CBLA? The issue is, would there be probably change the result if a new trial is granted? Would you agree?
Yes, I would agree with that. And I would think that that was perhaps just a shorthand or inartful way of saying that, because he does go through all of the evidence before he comes to that conclusion and talks about what evidence would have strongly incriminated this defendant without regard to the CBLA evidence. Your Honors, we ask that you find that there is overwhelming evidence of guilt in this case and that you affirm Glendale Moore's conviction. Thank you.
Thank you as well, counsel. Rebuttal?
Thank you, Your Honor. Honors. This case so much depends on all of these facts and looking at the evidence and who said this. And then you have the direct appeal where the court says, well, yeah, this psychiatrist testimony that he was exaggerating his symptoms, that shouldn't have been in, but it was harmless because we had the CBLA. Now we have the CBLA out, and we have the court saying, well, the CBLA shouldn't have come in because it's junk science, but it's harmless because we have all this other evidence. I contend that we really don't have that much other evidence. This, the 13-year-old Jeffrey Elmore, I don't think he was credible. I think you have the county attorney arguing, and
with regard to the boy, I mean, it's hard for us to know. This trial was 30 years ago, but I actually read the record, or at least that piece of it, and noticed there was very little cross-examination of the boy. And I wonder, I mean, one can draw two conclusions. One is that defense counsel thought he was credible, didn't think there was much he could do with him, and the other is thought he was sort of on his face, not believable, there wasn't much need to do anything. What conclusion do you draw reading this transcript, this sort of cold transcript 30 years later?
it's hard 30 years later, and I think trial counsel was, of course, doing the very, very best he could with what he had, and he didn't have the evidence that the witness had gotten a reward for his testimony. I think things like that would have made a big difference. And then at some point on another PCR, of course, Elmore tried to recant his testimony completely. And that's never looked upon favorably, and it wasn't by the court. And I think there was a suggestion that maybe Moore had somehow influenced him. But, you know, Elmore was really, if you take out the CBLA, that was the biggest evidence they had was this 13-year-old runaway from the juvenile detention facility. The other evidence is really, I was looking at the Court of Appeals that got us here that said basically if you take the CBLA evidence out, what you have is Moore had been married multiple times. He had some sort of relationship with females other than the victim. He'd not mentioned to the victim's daughters that he'd seen her earlier that day because he saw her at the grocery store. He headed off to Illinois to look at or whatever it was. But then he turned around and came back and came home and was there with the daughters at the time it came on the TV that there had been this car found. He didn't tell them he'd seen her earlier in the day. Then you have the testimony by the psychiatrist, which the Court of Appeals had determined shouldn't have been admitted. Then Moore stayed in a motel with his ex-wife a few days after it. After the event, he had a bulletproof vest in his car. He had a number of firearms and related items. They weren't ever linked to the crime. The murder weapon was never found. You have a deputy sheriff testifying that he had said at some unspecified time in the past that he had a .357 Magnum. And he
I want
had
to
a
go back
large-
for a second. We can sort of talk about facts all day, but part of the posture of the appeal as well, isn't it, even under the PCR, is not only the newly discovered evidence, but it is also a due process claim. Aren't you making that claim as well?
Yes.
And I guess I'm just going back to Judge Whirling's ruling. When you start talking about the totality of the circumstances and the de novo review here, isn't that why he had to make that comment in his opinion as well?
I believe so, and I think also when you look at all of the evidence, you take out the CBLA and you look at everything else, I can admit that he probably could have been convicted of being a very sleazy character. You know, I mean, he definitely did things that didn't look good for him. But guilty of first-degree murder, I simply still contend that there isn't the evidence necessary, and that's why we're asking for a new trial. Any other questions? Thank you.
Thank you as well, Counsel. The case of Glendale Moore Jr. is now submitted to the court, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.